document violate confrontation?
Your Honor, I believe literally out of this county with Judge Lockhart Mash, that went up to the Court of Criminal Appeals. The Court of Criminal Appeals ruled that that was sufficient on its own. I'm trying to get the exact case. I could find that out, but that literally came out of this.
And here's the bombshell. While already out on bond, Rebecca racks up another domestic assault charge. That alone can be enough for the state to slam the brakes on her freedom. But remember, an arrest isn't a conviction, so should it really cost her bond? What do you think?
Out of this very circuit court county, Your Honor.
I don't have the case in front of me, but I'm understanding that is the rule that has been adopted by our Court of Criminal Appeals. So as a result of that, I will have this marked. It is a certified copy. I'll have it marked as Exhibit 1, and that is the state's proof under the statute, which allows the state to seek the revocation of bond based on a subsequent arrest for a person who's on bond. Is that correct? All right. Mr. Flanagan, do you wish to offer any proof?
Maybe. This motion to revoke bond, and that's the DA's office here always styles it that way, but they leave off the other options. It's a motion to revoke, alter, or amend. So this thing that's been handed to you is now an exhibit is maybe sufficient to show that the bond condition has been violated, but the court has discretion on what to do with it. And so I think that's where we are. So if the court is now ruling that they have sustained that the bond condition has been revoked, then we'll go to what needs to be done.
Well, based on that case that Mr. Stevens has referenced, is in my own understanding of the current state of the law, a certified copy of a subsequent arrest record is admissible, and under the statute that the state is proceeding under, they have the right. It doesn't require conviction. It says anyone who is on bond or in bail and is arrested.
Notice the judge laying out the three choices here: revoke, raise, or restrict. It's not always all or nothing. This is where defense lawyers love to argue for the middle ground, because total revocation is basically jail until trial.
On a subsequent offense, that the court has the option of revoking their bond. So
Yep.
I think that the state has met its burden to show that there is a basis for the court to consider any revocation of the bond, or as you state, the statute allows for modification of the bond. So the state, in my opinion, has met its burden to show that there is a basis for review of the defendant's bond, either a revocation or a modification. So if you wish to offer any proof about that, then I'll be glad to hear it. So.
Well, I guess my position is now, has the state put on enough just with that to justify a revocation of the bond? I mean, that's all the proof you have before Your Honor. So you got three choices. You can raise the bond. You can put different restrictions on her. So my position is they have not met the burden to show that one of these other options is not appropriate. So I'm asking the court, as a matter of law, to alter or amend the bond.
So you're basically asking me to alter or amend it, okay?
Yes, because
I understand what you're asking.
Yeah, they put that.
Let me hear what the state's argument is. If we're not going to have any proof, then I'll let you both argue what you think the appropriate disposition is.
Well, but let's do it this way. I can have just a moment.
Okay.
Would you state your name for the record and please spell it?
Shonda Vargas. It's SHONDA VARGAS.
Okay. Ms. Vargas, where are you employed?
Serenity Ranch Recovery in Mammoth Cave, Kentucky.
Serenity Ranch?
Yes, sir.
Okay. And has Ms. Miles already been admitted there?
Yes, sir.
And
Turn your microphone on.
a new charge you've already carried the burden on that, General. New charge has occurred. We're talking about disposition.
So just to clarify, is this, so as Mr. Flanagan seceded the point that his client violated the conditions of bond, and this is for the purposes of what to happen, because at this point, I think it's irrelevant to whether or not she picked up new charges while on bond.
The court's already ruled in your favor on that, General.
I've ruled, as a matter of a finding that I've made, that the introduction of this certified copy is sufficient to meet the burden that the state has to show that there is a basis for the court to consider whether or not to revoke the bond. So I've made that finding. Mr. Flanagan is now wanting to produce proof that would offer alternatives to the actual revocation.
Smart move by the defense. Instead of just begging for leniency, they bring in a rehab program rep. This flips the narrative from punishment to treatment. But here's the million-dollar question. Does rehab outweigh a fresh domestic assault charge?
By offering, I'm assuming, some testimony that would indicate there is a basis for a modification of the bond, which is one of the options that the court has in this particular case. So as far as relevance, it is relevant, and I don't know, I haven't heard everything, but if it's relevant as to what the defendant's present situation is and what, if any, modifications should be made versus revocation. So I'm going to, unless you have some other basis for the objection, I'm going to allow it to proceed.
Yes, sir.
Tell the court about the program.
It's a 28-day detox and residential program where we help individuals overcome substance abuse disorders, and we also deal with mental health, so we are dual diagnosis. After the 28 days, we do help clients go to the next step, which would be a partial hospitalization program, a PHP. We do help them get that set up if that is something that they are interested in to continue their recovery, to help them in that sort. We have therapy, we offer therapy, case management, and things of that sort, also group therapy. It's just kind of to get them to go on to the next step in their recovery.
Okay, so she's been admitted.
Yes.
Been there a couple of days, right?
I want to say she's been there about a week, but I'm not
Okay,
positive
about a week.
that. Yeah.
And she'll be there for at least 28 days?
Yes, sir.
Could it be longer?
Not in our program, but we can set it up so she can go straight from our program to another program that would be 30 to 90 days.
Okay. And at my request, you brought her here today because you knew she had to be in court.
Yes, sir.
If she were to leave the program, would you notify me and/or the district attorney and the court that she left the program?
Yes, sir.
That's all I have for her.
Stevens, do you have any questions? You don't get off that easy. The state has the right to ask you questions.
This is kind of nerve-wracking.
Good afternoon, or good morning, ma'am.
Yes.
Just a few questions for you. So when you go through that, are you aware of any of her prior charges as part of this when she goes into a program?
Yes, sir.
Okay. So you're aware of about 20 prior domestic charges?
I mean, I'm not personally, because I don't do the admission part. I work with the clients on a daily basis. That's all. That's my job.
Okay. What about 20 prior charges for violating conditions of bond?
Again, that's not my job. I don't do the admission part. I just help the clients when they come in.
What about 5 times failing to appear?
Again, that's not my job.
Okay.
I don't work with the admissions. I don't know what we know about her prior charges, but I do know that she had charges because we brought her to court today.
Are you aware she's a convicted felon for aggravated assault?
I mean, most people there are.
Okay.
Yeah.
That's all that I have. Thank you.
Nothing further, this witness.
Thank you,
If the
ma'am. You
court
may step
doesn't have
down.
any questions.
Whoa, this just got messy. The husband, who's also the alleged victim, is testifying, and the judge is already warning him, if he changes his story from what he told police, he could incriminate himself. That's the legal equivalent of walking on a tightrope over fire.
Any other witnesses?
No, Judge.
State wish to offer any proof?
Her husband, Mr. Robert.
All right. Mr. Robert Miles?
Yes, sir.
So it has to do with the disposition. And Judge, before we get started, because I don't represent him, he is the victim in this assault. I think the state is going to ask him questions about what happened. And I explained to him that if his testimony here today today is different than what he told the officers, he could be charged for filing a law. I don't represent him, if the court wants to talk. And I told him I don't want to put him, that's why I didn't call him, because I didn't want to put him.
Mr. Miles, well, first of all, Mr. Stevens, are you intending to ask him about the factual basis of it?
I am, Your Honor.
Mr. Miles, you are the alleged victim in this case that's being used by the state as a grounds for the revocation of Ms. Miles's bond. In that, the officer who made the arrest is stating that you gave him information that, and I'll read this to you. It says, I made contact with Joseph Miles in front of the residence while Sergeant Mutter spoke to Rebecca Miles on the front porch of the residence. Joseph explained that him and Rebecca were eating Chinese food in Bellevue. Joseph stated him and Rebecca got into a verbal altercation at the restaurant. During the verbal altercation, Rebecca stabbed Joseph in the right hand with a fork. And then it also says that once you returned to your residence, Joseph stated that when he turned on Trace Creek Road, Joseph stated Rebecca started striking him in the face, chest, and groin. And I observed noticed a bruise under Joseph's right eye. So what Mr. Flanagan is wanting you to understand is that if you gave information to a police officer that they used in reliance on obtaining a warrant against your wife for domestic assault, and you are asked those questions today under oath, and you answer differently than that, there is a possibility that you could be subjected to criminal prosecution yourself, because there's a statute that makes it a crime to give false information to a police officer. Sometimes people get mad and they say things to an officer, they make a false report. And the reason they make a false report is because they're angry, upset, or whatever, and it's not true. But sometimes people decide they don't want to really, have to see what happens, so they want to change their story. But you have to understand that when you testify today under oath, then those questions, those answers could be used as evidence against you if you change your version of what happened. You also, as a citizen of this country, have a right under the Fifth Amendment of the Constitution to decline to answer any question that might tend to put you in danger of criminal prosecution. You understand that? You understand everything I've asked, I've advised you of?
I can decline the question.
You can decline to answer a question if you think your answer could potentially put you at peril for criminal prosecution. You can decline to answer because your answer might tend to incriminate you in criminal prosecution. Do you understand that? All right. You understand everything I've explained to you?
Yes.
All right. Mr. Stevens, you may ask.
Sir, please state your name.
Joseph Miles.
And Mr. Miles, how do you spell that for the record?
Joseph Miles.
Mr. Miles, who is your spouse?
Rebecca Miles.
And how long have you been married?
It's about 3 years now.
3 years. What was her maiden name?
Rebecca Fain. Fain.
How do you spell that, sir?
Fain.
Did something happen to you on August the 1st that leads us to court today?
Yes.
And what was that?
We got in the argument.
There it is, straight from the husband. A scratch on the hand with a fork during dinner. Not exactly a deadly weapon, but combined up with threats to slit his throat, that escalates things fast. And the court has to decide if this is just a lover's quarrel or something much darker.
At the restaurant.
About what?
She said that I was looking at a lady's butt, and I said I was talking about the bucket that had soy sauce on it.
Okay.
And she thought I was looking at the lady's butt.
Where was that at? Was
got
that in
mad
Dixon
at me.
County or another county?
It was in Bellevue,
Davidson County, to your knowledge?
Davidson.
What did she do in response to that argument?
She hit me with a fork. I think that's what it was. I had my hand laying there, and she just hit me with it.
Okay. Did you have any marks from that?
I had a little scratch on my hand.
Okay. Still there today? Still there today with a mark?
No.
Okay. Now, Mr. Miles, did you drive home after that?
Yeah.
Where'd you go to?
Went home
And where's that at?
on Trace Creek Road.
Is that in
White
Dixon
Bluff.
County?
Right in White Bluff.
Okay.
Dixon.
White Bluff, Dixon County?
Yes.
Now, on the way home, what else happened?
We argued. And it wasn't really a hit. She was just pushing, and I was kind of pushing away from her. And it was just a little altercation there, just back and forth.
Now, did you talk to an officer on scene?
Yes.
Officer sitting at court, at a table with me right here?
Yeah. Yes.
Now, as part of that, what did you tell the officer happened?
I told him at the restaurant we had an altercation and just had the argument.
Did you mention where she said she was going to slit your throat at bed?
I think I might have mentioned that.
Multiple times?
I think I mentioned it once.
Okay. As part of that, did you tell the officer that she hit you right up there on that hill, right at the hill you can see right here, which would have been in Dixon County? Did you tell him that?
It was on the hill above the house.
So she struck you while you were in Dixon County?
Well, we was pushing each other.
Okay. You aware she's on bond for a matter, correct?
On bond?
Correct?
Oh, yeah.
Involved striking a
Like
school
wreck.
bus, is that correct? Striking a private school bus that caught on fire?
Correct, yes.
And you're aware she's a convicted felon?
Yes.
You're aware that one of the charges was she had a gun in her purse?
That, I didn't know she had a gun in her purse.
You didn't know that?
No.
Were people from the family calling Officer Lewis asking for the gun back before charges were made?
Her son asked me about the gun. It was his gun.
Okay. In her purse, correct? Or you don't know?
I don't know if it was in her purse.
What pills does she take? What medication does she
That's
prescribed?
medication, oxymorphone, and something else.
And she'd
for
have,
her back.
she'd have a prescription bottle of that,
His
correct?
prescription.
Would that be in her purse as well?
I think it was in her purse.
And you're aware the charges include allegations of a child and bus driver on this bus as it caught fire that she hit. You
I didn't
understand
know
that?
there was a child on the bus.
You didn't know that?
Later.
Okay. 1 second, Your Honor. All I have at this time, thank you.
Boss?
Mr. Miles, you and I have talked about your wife's substance abuse problems.
Yeah.
And one of the things that you and I talked about, did we not, was trying to get her treatment.
Yes.
And that this altercation, she was somewhat under the influence of that. I mean,
Yes.
basically attacked you for looking at somebody.
Yes.
Okay.
She's very jealous.
Very jealous. Our goal, when I say ours, that what you and I had talked about, was to try to get her in treatment to address that problem.
Right.
And you would agree that this new arrest is basically based on her substance abuse problems?
Yes.
And you want her to get help?
Yes, I do.
Okay, that's all.
Step down, Mr. Miles.
And now the real hammer drops. Previous charges include slamming into a school bus while allegedly intoxicated, with a kid inside, at a .13 blood alcohol level, prescription opioids, and a gun in her purse. This is stacking up into a nightmare rap sheet. So audience, here's the question. Do you think rehab is enough, or is jail the only option here?
State may call your next witness. Step right up here, Officer Lewis, and will raise your right hand and be placed under oath.
Sir, please state your name for the record.
Daniel Lewis,
And she may have already asked some of this, but how do you spell it?
Daniel Lewis,
Where are you employed?
Dixon Police Department,
How long have you been employed with the department?
almost 9 years.